We've got Labour tenants farmers, which triumphed at the highest court in the land. It happened today. The Constitutional Court ruled in favour, allowing Special Master to process their claims instead of the Department of Rural Development and Land Reform. So some of the claims being brought by the farmers are 22 years old. The Deputy Director of the Legal Resources Centre, Teresa Vergerif, joins me now in studio for that conversation. Teresa, thanks a lot for joining us this afternoon.
Thank you.
Tell us exactly what does this mean, especially for those farm tenants who were actually living on the farm, let's say for about 20 years, working on the farm, living there, and finding themselves being kicked off the farm because maybe a new owner has subsequently come onto the farm.
Thank you, Faith. I think we must understand that Labour tenants are a special category of farm dwellers. So most people who fall within, well, all people who fall within the category of Labour tenant have a historic link to land, which means that they and their families have been living on and working on the land over generations. So while younger people may have been born on the farm and been there for 20 years, they can trace the history of their families on the farm back over generations. And the Labour Tenants Act was passed in 1996 in order to recognize the dispossession of these groups of people over time under the apartheid system, and to give them an opportunity to claim via this act to gain security of tenure and to live in peace and security on their land.
I mean, obviously that would mean that, and you know, putting it in layman's terms here, is that this specific ruling has allowed actually for that let's say that you've been living on the land, let's say for about 40 years, so sometimes generations, as you mentioned. My grandmother lived on it, was working on it, and then I subsequently...
Your family graves are there.
Exactly, my family graves are there, etc. That now, according to this ruling, that I can have that piece of land, that portion of land is now legally mine, and also the aspect about how you're able to even have livestock on that land.
Well, Faith, the ruling doesn't confer ownership of the land to the Labour tenants. What the decision decided, the court decided that a special master should be appointed to have oversight of the department's administration and finalization of the outstanding labor tenant claims, because people had until 2001 to make their claims, and after 2001 the department, well, up until 2015, the department was stating that it had an estimate of around 19,000 labor tenant applications that had been received. We don't know if that's an accurate number. It may be, and possibly it is more than the 19,000. Since that figure was published by the department, they claim that they have finalized 9,000 claims. But we don't know what that really means. So it has been very difficult to get accurate and detailed information about what's happening with the claims from the Department of Land Affairs, and many commitments from the Land Affairs to our clients and to our attorneys were not kept. So our lawyers, the Legal Resources Centre, asked the court to appoint a special master, which is really an extraordinary step by a court to take in South Africa, because it's basically saying that the department really has had more than 20 years to resolve these issues, and it has failed to do so. And therefore, the court is within its powers to take the extraordinary step of appointing a special master, someone from outside the department, an independent person who will be a direct liaison between the department and the court and the clients in order to monitor what the department is doing to settle the claims. So the special master, him or herself, will not actually be finalizing the claims, but will have some oversight and expertise in the area so that that person can also give advice and direction to the department as it moves forward.
I take the point of the fact that it's quite a big step as compared to where it was, let's say, even in 1996, never mind in 2001 when the claims were actually lodged in itself. However, then at this particular moment in time, especially when it comes to your clients, what rights do they have over that land? Do they even have any rights over that land? Can they still be evicted? Let's say that a new farm owner comes into play, and can they still say, listen, Mrs. So-and-so and your family and your livelihood, you have to get off my land because now I'm the new owner?
Well, there's always a possibility of that happening, but in theory, according to the Act, our clients, at least having lodged their application for tenure security in terms of the Act, they have a right to continue their occupation of the land and their use of the land in a manner in which they have been doing so over years. But we know from prior experience that often, sometimes if a new owner comes in, or if a current owner decides to change the use pattern of the land to switch from perhaps farming to game farming, then sometimes people are evicted. So it's never truly secure on land until you have a title deed and a declaration that some kind of declaration that it is your land. In terms of our clients, the 4 named respondents in our clients, those families have lost 4 members since the litigation started in 2013, and 2 of our clients have died in the past 2 months. So it's also important to know that these have been struggles that have been going on for generations, and the promise of 1994 with our Constitution in 96 and the new legislation that came to being in the wake of the Constitution, the promise was that these issues would be resolved, that people would be able to gain tenure security in terms of Section 25(6) of the Constitution and live according to customs and practices that they have been living according to over generations.
But unfortunately, we know that when it comes to government use, and I'm sure that with your experience and extensive being able to be really intimate with this case, you've seen that we're perhaps really good with policy, perhaps we're very good on theory, but practical implementation still becomes a part where we do lack. And unfortunately, in this instance, we should never forget the people that are at the bottom of it and the people that are most vulnerable. These are the people that have to live with the realities every single day. It brings about the question of land ownership once again into the fold in our conversation. But we have to leave it there for this afternoon. But
absolutely.
Thanks a lot
Thank you
for joining us and shedding some light today in terms of exactly what are we talking about when we talk about these farm dwellers as well as labor tenants, of course, from the Legal Resources Centre, Teresa Vergerif.